Hello, in this clip what I'd like to do is talk about children and in particular the problems that might occur when parents separate. Now specifically that relates to residence and contact, commonly what people will call custody and access. From a legal perspective, it's often seen that at this difficult time what children need is stability and security. That involves a home base. Now it may be, for example, that the children are looked after by the mother and she's the primary carer, but that is not to reduce the importance of the father's role in that stereotypical situation. It's very important that whilst a parent may have rights, to recognise that the children have rights to know and have a loving, ongoing relationship to both parents. Invariably, however, where people do separate, there's problems to do with the relationship, there may be worries and anxieties to do with the finances, and that can overspill and manifest itself in relation to problems with the children. It is important that any issues are dealt with swiftly and in the best possible way. The legal test really is what is in the best interests of the children, and we have a checklist of factors, and that often goes to each individual case, looking at what is best for the children in that particular circumstances. There could be some geographical distance between the parents, there may not be, there may be something to do with the age of the children. It's obviously a big difference between children who are infants compared to children who are teenagers, so we need to look at the issues on an individual basis. It can be possible, with the assistance of lawyers or without the assistance of lawyers, to actually reach an agreement between the parents. If there are difficulties, then there can be correspondence to put forward certain proposals to reduce areas of conflict and to promote an overall agreement. Where there are ongoing problems, however, or in urgent situations, it might be necessary to make an application to the court. The procedure and steps to be taken there largely consist of a first hearing. So following a parent's application, the court will automatically list the case for a conciliation appointment. Subject to local practice, there will often be what's called a CAFCAS officer present as well. In layman's terms, a welfare officer who may want to speak to the parents together or separately to look at the welfare issues and to see whether or not an agreement can be reached on that day. The parents will then attend before the judge privately and with their legal representatives. The judge will want to know what's happening, what's agreed, and what areas of the case remain in dispute, and therefore what needs to be done. The directions from the court moving forward could include narrative statements, so we know what the evidence is. It could also include the need for a welfare report. The court may then list the case for a review hearing, which would take place after the evidence has been completed and the report also completed. It's important then to look at the issues in light of what's before the court at that time, and in a lot of cases an agreement can actually be reached and an order agreed and dealt with by consent. In those cases, however, where the issues are still difficult or it becomes complex for lots of different reasons, then the court will traditionally list it for a third hearing, and that will be a final hearing, where ultimately a judge will hear oral evidence from the parties, consider welfare reports that are available, and make a final decision. Thank you.